The Court of Appeal is the highest court within the senior courts of England and Wales, and second in the legal system of England and Wales only to the Supreme Court of the United Kingdom. The Court of Appeal was created in 1875, and today comprises 39 Lord Justices of Appeal and Lady Justices of Appeal. The court has two divisions, criminal and civil, led by the Lord Chief Justice and the Master of the Rolls and Records of the Chancery of England, respectively. Criminal appeals are heard in the criminal division, and civil appeals in the civil division. The criminal division also hears appeals from the Crown Court, while the civil division hears appeals from the County Court, High Court of Justice and Family Court. Permission to appeal is normally required from either the lower court or the Court of Appeal itself. And with permission, further appeal may lie to the Supreme Court. The appeal system before 1875 was chaotic. The Superior Courts system consisted of 12 different courts, with appeal on common law matters to the Court of Exchequer Chamber, Chancery matters to the Court of Appeal in Chancery and other matters to the Privy Council. This was the subject of a review by the Judicature Commission, established in 1867 to consider the creation of a Supreme Court. The result was published in 1869. The recommendation was that there should be a common system of appeal from all of the High Court divisions, with a limited set of appeals allowed to the House of Lords. This reform was implemented by the Judicature Acts, with the Appellate Jurisdiction Act 1876 giving an almost limitless right of appeal to the Lords. The new legal structure provided a single Court of Appeal, which heard appeals from all the various divisions of the new unified High Court of Justice. It only heard civil cases. Opportunities for appealing in criminal cases remained limited until the 20th century. In its early days, the Court of Appeal divided its sittings between Westminster Hall for appeals from the common law divisions, and Lincoln's Inn for Chancery, probate, divorce and admiralty appeals, with 5 Lords Justices. After the opening of the Royal Courts of Justice in 1882, the Court of Appeal transferred there, where it remains, as well as the Lords Justices, the Lord Chancellor, any previous Lords Chancellor, the Lord Chief Justice, the Lords of Appeal in Ordinary, the Vice-Chancellor of the Chancery Division and the Master of the Rolls could also hear cases. Although in practice only the Master of the Rolls did so, the absence of limits on appeals to the House of Lords was the cause of much concern. It led to an additional set of expensive and time-consuming appeals from the Court of Appeal, which thus could not take decisions in the knowledge that they were final. The appeals from the county courts were seen similarly, involving an appeal to the High Court of Justice and the bypassing of the Court of Appeal for a second set of appeals to the Lords. The Administration of Justice Act 1934, a short statute, solved both problems neatly by abolishing the appeal of county court decisions to the High Court, and instead sending them automatically to the Court of Appeal, and by establishing that appeals to the Lords could only take place with the consent of the Court of Appeal or of the Lords themselves. A second set of reforms to the appeals system followed the report of the Evesham Committee on High Court Procedure in 1953, which recognized the high cost to the litigants of an additional set of appeals, particularly since the loser in a civil case paid the victor's legal bills. Among the few changes that were made, the practice ceased of counsel reading out the judgment, cross-examinations, documents and evidence given in the lower court. This saved time and costs. The process of leapfrogging, which the committee had recommended, was eventually brought into force with the Administration of Justice Act 1969. A separate Court of Criminal Appeal had been established in 1908. In 1966 this was merged with its older namesake, establishing the present-day structure of a single Court of Appeal with 2 divisions, civil and criminal. In the early 1960s there was discussion between judges and academics in the United Kingdom and the United States comparing the processes of appeal used in each nation. Although the British judges found the emphasis on written arguments unattractive, they did like the idea of pre-reading, that the court should read the pleadings of counsel, the case being appealed and the judgment from the lower court before delivering its judgment. But the idea was quietly scrapped. Despite a successful tryout in the Court of Appeal, the court over which Lord Denning presided from 1962 to 1982 was under no pressure and had no inclination to modernize, with liaisons and management handled by clerks with little knowledge. This changed in 1981 with the appointment of a registrar, John Adams, An academic and lawyer. Who signif.